All rise. We will.
Molim, ustanite.
Very well. You don't have to repeat appearances as before.
Please be seated.
When we broke off, the defense were making their submissions, and as at the time when we broke off, according to my record, you have 2.5 hours remaining of your allotted time. This session will last 1 hour until 12:30. You may proceed.
Thank you, Your Honor. Just before we begin, to put on the record that for the first 25 minutes of the break, I was unable to have telephonic communications with my client due to technical issues. That has now been resolved. Thank you.
Sorry, can you repeat that again,
Mr. Mladić? During the first 25 minutes of the break, the telephonic line, privilege line, did not function, and I was unable to speak with my client. That has now been resolved. So for half the break, I did not have an opportunity to speak to Mr. Mladić.
I think we should allocate this time to the defense at the beginning of this session, which means their time will be 1 hour, 25 minutes for this session. We may proceed. Mr. Lukic?
Mr. Mladić, Madam President, can you please clarify?
Sorry?
Can you please clarify? We're not sure as to what the last portion of what you said indicated.
Okay, the audio is not very clear. My understanding is that you said you lost 25 minutes because of miscommunications and breakdowns in the communications. Is that correct?
No, Madam President. During the recess of the proceedings, I was unable to have privileged communications with my client due to technical difficulties, and therefore did not have access to my client for approximately 25 to 27 minutes of the allocated 1 hour break.
Okay, so you lost 25 minutes of all the time you should have spent with your client during break due to miscommunications?
That's correct, Your Honors.
You want to consult with your client now before we proceed?
No, Your Honors, we can proceed. I'm just making a record.
Very well. You may proceed, Ms. Bagot.
Madam Presiding Judge, Your Honours, before the break, I was addressing the Chamber on why the presentation of a general defence case and cross-examination did not cure the errors in relation to Ground 1. Absent notice, and specifically of the crimes alleged, the defence could only put forwards a general one. And a general defence cannot counter a specific accusation or incident. In relation to cross-examination, this can only be deployed to undermine the prosecution's case when the defence knows in precise terms what case it has to meet and the incident to which the prosecution seeks a conviction on. In addition, meaningful instructions can be taken in this regard. Absent notice, neither can cure the trial chamber's error. The prejudice suffered by Mr. Mladić lies in the fact that these accusations were transformed into unscheduled incidents by the trial chamber at the judgment stage. Therefore, it was too late for the defence to defend against them in the same way that it would with scheduled and unscheduled incidents that it was put on notice of. The impact of this error. As a result of the trial chamber's error, Mr. Mladić was held criminally responsible for these unnamed unscheduled incidents, which constituted crimes against humanity, terror, unlawful acts, and persecution. The trial chamber then took these into account when determining the ambits of the count on the indictment and the extent of his criminal responsibility. For the reasons set out, the appellant invites this chamber to reverse the findings on the crimes identified in paragraphs 52 to 58 of the appeal brief. Turning now to ground 2. The appellant submits, first, that there are compelling reasons for this chamber to revisit Camrera to determine whether the trial chamber erred by taking judicial notice of facts relating to Mr. Mladić's proximate subordinates under Rule 94B, and second, that the trial chamber erred by applying a heightened standard to rebuttal evidence. These will be taken in turn. The appellant's submissions on Camrera are at paragraphs 62 to 95 of the appeal brief and paragraphs 16 to 19 of the reply. The ICTR Appeals Chamber held in the Camrera interlocutory decision that facts relating to the conduct of the physical perpetrators of crimes for which an accused is alleged to be criminally responsible may be subject to judicial notice, paragraph 50. The appellant submits that the relevance of the Appeals Chamber's findings in the Garlich Rule 92 bis C decision and the Milosevic interlocutory decision lies in the further guidance they issued about the circumstances in which trial chambers should withhold their discretion in this specific context. The Garlich Rule 92 bis C decision considered that admitting Rule 92 bis evidence that went to the conduct of the, quote, immediately proximate subordinates, close quote, of an accused was inherently unfair when they were charged under Article 7.3 or the evidence goes to the elements of Article 7.1. It decided this on the basis of what it considered to be the, quote, short step, close quote, from a finding that crimes charged were committed by such subordinates to a finding that the accused knew or had reason to know that these crimes were about to be or had been committed. Paragraph 14. The Appeals Chamber said that careful consideration should always be given by trial chambers to the exercise of its discretion in these, quote, special and sensitive, close quote, situations. Paragraph 19. The Garlich Appeals Chamber did not define immediately proximate subordinates with reference to the rank of an accused, but rather whether the conduct of them was so widespread that the inference would be drawn that, quote, there is no way that the accused could not have known about it, or the accused had to be aware, close quote, of the objectives of his subordinates. Paragraph 14. It considered that where this link became sufficiently pivotal to the prosecution's case on responsibility, quote, it may not be fair to the accused, close quote, to permit this evidence in written form as it could not be challenged by the defence. Paragraph 15. In the same vein, but specifically in the context of adjudicated facts, the Appeals Chamber in the Milosevic decision held that, quote, while it is possible to take judicial notice of adjudicated facts regarding the existence of crimes, the actus reus and mens rea element supporting the responsibility of the accused for the crimes in question must be proved by other means than judicial notice, close quote, paragraph 16. It distinguished this from adjudicated facts that provided evidence as to the existence of crimes committed by others for which the accused was not charged with, paragraph 16. Therefore, both appeals chambers considered that if the link between the accused and the crime committed was such that the responsibility of an accused could be easily inferred from the untested witness statement or adjudicated fact, then the prosecution would have to establish this by calling evidence that could be confronted by the defence. This, the appellant says, is the conceptual issue that was overlooked by the Camara Appeals Chamber and why the Mladić Trial Chamber's reliance on it led it into discernible error. An example. The judgment highlights that the trial chamber took judicial notice of facts that related to the criminal activities conducted by those the prosecution alleged were Mr. Mladić's subordinates to hold him responsible for them.
Backward, could you kindly pause? We have dropped the signal for the presiding judge. Thank you.
The counsel is also asked to slow down for purposes of interpretation. She is going quite fast. Thank you.
Jeez.
Madam Presiding Judge, are you in a position to hear and see us now?
Sorry?
We have re-established connection, it appears.
Okay, you may proceed.
Madam Presiding Judge, it might assist if you could let me know what the last thing you heard was before I cut out.
You had started talking about, you are into county 2.
How far into count 2?
Yes. You may proceed where you left.
Madam Presiding Judge, I'm just conscious of the fact that other judges and particularly other people in the courtroom would have heard my submissions, and I'm conscious of the fact that if you cut out, perhaps you've missed a portion of it. And if it would assist you, I can go back.
Regrettably, I'm unable to help because I can hardly hear you or any other judge. I'm thinking we are going to rely on the transcript when it is eventually generated because, excuse me, unlike normal proceedings, I should have a transcript on the screen to follow the proceedings. I don't have that possibility.
I will take it from where I left off, and then the transcript will reflect the words that I spoke in the
Yes.
interim period.
Okay.
By way of example, I would refer the Chamber to incident of the 23rd of July 1995 at paragraph 2210 of the judgment. The trial chamber took judicial notice of a number of adjudicated facts in relation to the SRK's possession of modified air bombs between August 1994 and November 1995, and relating to a shelling incident on this day. It specifically took judicial notice of the fact that, quote, the modified air bomb was fired from a northwesterly direction from SRK held territory, close quote. Paragraph 2210, footnote 9385, an adjudicated fact 2871. On the basis of a judicial fact alone, no prosecution evidence, it concluded that, quote, a member or members of the SRK launched a modified air bomb, close quote, on that day and killed 2 civilians, seriously injuring others. Paragraph 2212. Pausing there. The prosecution's case was that Mr. Mladić was the most senior officer in the VRS and that he significantly contributed to achieving the objectives of the JCEs primarily through the use of the VRS forces. Indictment, paragraph 13. These specifically included the SRK, which the prosecution said, quote, implemented, quote, quote, Mr. Mladić's orders through ethnically cleansing municipalities and terrorizing Sarajevo's civilians through a campaign of shelling and sniping. Prosecution final trial brief, paragraphs 102 to 103. In light of this, the adjudicated fact established that the crimes charged were committed by Mr. Mladić's alleged subordinates. Given that the prosecution's case was that the SRK were implementing Mr. Mladić's orders and were used as tools to achieve the objectives of the JCEs, the adjudicated fact on the identity of the perpetrator went to the core of its case on his responsibility. Despite this, the trial chamber took judicial notice of this fact in the absence of any prosecution evidence that could establish the SRK's responsibility for the incident. The appellant submits this example demonstrates the error with the trial chamber's reliance on the Camara approach. The trial chamber considered that there were no limitations on which judicial facts could be taken, judicial notice could be taken of, in the context of the conduct of other members of the JCE or the physical perpetrators. This is just one example of when the trial chamber took this approach in relation to Mr. Mladić's alleged proximate subordinates. The appellant invites the chamber to consider the others identified, for example, at paragraphs 107 and 108 of the appeal brief. It is important to consider how other trial chambers have exercised their discretion to highlight the divergence in practice. I would refer the Chamber to paragraph 69 and footnotes 97 and 98 of the appeal brief in this regard. There are broadly two approaches that can be seen in the jurisprudence: the Camara approach and the Milosevic approach. An example of the latter is an approach taken by the trial chamber in the Stanisic and Juplagin case. The judges held that, quote, where the proposed fact goes to the core of the prosecution's case and relates to the conduct of others for whose criminal acts and admissions the accused is alleged to be responsible, the trial chamber will nevertheless exercise its discretion to withhold judicial notice if it considers that doing so would be in the interests of justice. Paragraph 41. In light of the prosecution's case against Miko Stanisic and Stoyan Juplagin, namely that in their roles as the Minister of the RSMUP and Chief Regional Security Services Centre of Banja Luka respectively, that they committed crimes through the police, the trial chamber concluded that, quote, where a proposed fact refers to the criminal activities conducted by the police within an ARC municipality, the fact is considered to go to the core of the case. Close quote, paragraph 41. For that reason, it withheld judicial notice of such facts in the interests of justice. Importantly, the trial chamber in this case did not limit which members of the police this would apply to by, for example, rank. Given the prosecution's case, it considered that all members of the police could constitute the accused's, quote, immediately proximate subordinates, close quote. This demonstrates that, contrary to the prosecution's assertion at paragraph 30, this is not limited to those close to an accused in rank. Had the Mladić trial chamber taken this approach, it would have withheld its discretion and declined to take judicial notice of facts that related to the criminal activities conducted by those the prosecution alleged were Mr. Mladić's subordinates in the interests of fairness. The appellant submits that the fact that there is such a divergence in the approach taken in the jurisprudence gives further impetus to revisit the appeals chamber's decision in Camara and articulate the correct legal standard. By way of conclusion, the appellant emphasises that it is not argued that the trial chamber can never take judicial notice of facts. The appellant asserts that the trial chamber fell into error when it admitted a specific category of facts, namely those that related to the criminal activities conducted by those the prosecution alleged were Mr. Mladić's subordinates acting under his orders. As, the appellant says, these were sufficiently pivotal to the prosecution's case on his responsibility for the alleged conduct. Therefore, it should have presented evidence itself in this regard. The appellant invites this chamber to find that the trial chamber erred in exercising its discretion and overturn the relevant findings affected by this approach, identified, for example, in paragraphs 107 and 108 of the appeal brief. Ground 2A.2. The trial chamber erred by applying a heightened standard to rebuttal evidence. The appellant's submissions on this ground are at paragraphs 94 to 114 of the appeal brief and paragraphs 20 to 37 of the reply. Taking judicial notice under Rule 94B creates a rebuttable presumption of accuracy of that fact. However, as the trial chamber acknowledged at paragraph 5272 of the judgment, the ultimate burden of persuasion remains with the prosecution. The appellant submits that the standard applied to the defence rebuttal evidence was heightened. As a result, it was deprived of its opportunity to enliven the debate, and from that, rebut the adjudicated fact. Turning first to the standard articulated in the jurisprudence. Within this, it states that the defence bear the burden to produce credible and reliable evidence sufficient to bring the accuracy of the adjudicated fact into dispute. The threshold of credible and reliable rebuttal evidence, as the Camara rebuttal decision states, is, quote, relatively low. What is required is not the definitive proof of reliability or credibility of the evidence, but the showing of a prima facie reliability and credibility on the basis of sufficient indicia, close quote, paragraph 151. The trial chamber itself recognised in its decision on adjudicated facts that the accuracy of facts could, for example, be challenged through the cross-examination of prosecution witnesses or the presentation of defence evidence to meet this threshold, paragraph 19. Therefore, contrary to the prosecution's assertion at paragraph 37 of the response, the defence was not required necessarily to present rebuttal evidence as part of its case to bring the accuracy of the adjudicated fact into dispute. It was, as the trial chamber acknowledged in that decision, enabled to do so by confronting the prosecution evidence and eliciting inconsistencies and weaknesses therein. Despite this, the trial chamber imposed an erroneous additional requirement on the evidence presented by the defence. It required it to be, quote, unambiguous. Examining the approach the trial chamber took. The trial chamber explained at paragraphs 5273 how the defence could enliven the evidentiary debate. Quote, in either presenting evidence on a specific alternative scenario as opposed to a mere suggestion of one or more possible alternative scenarios, or in the unambiguous demonstration that a scenario as found in the adjudicated fact must reasonably be excluded as true. Close quote. To further explain what it meant by a, quote, specific alternative scenario, close quote, it gave an example in the only footnote within that paragraph. It reads, quote, if an adjudicated fact stated B killed C, and the trial chamber received evidence that C was possibly / likely killed by A, close quote, it said this would be deemed insufficient to reach the threshold of unambiguous evidence. Footnote 18018. Let's consider that for a moment. If something is possible or likely, then there is doubt. And where there is doubt, as is trite in criminal law, that doubt must be resolved in favour of the accused. To expect the defence to present evidence that is without doubt is to reverse the burden of proof and impose a heightened standard, that of beyond reasonable doubt. It follows then that eliciting doubt through cross-examination of prosecution witnesses, such that inconsistencies or weaknesses could be pointed out, would not be sufficient. Therefore, following the trial chamber's example, to challenge the accuracy of the adjudicated fact on the basis of its standard, the defence would have had to have proved beyond reasonable doubt that C was killed by A, and it would have had to have done so by presenting evidence in this regard. There is no legal basis for this standard. The fact that the trial chamber does not cite a single authority for it in paragraph 5273 is perhaps indicative of this. In the next paragraph, 5274, the trial chamber stated that it is, quote, mindful that evidence contradicting the adjudicated fact does not automatically rebut the adjudicated fact, close quote. The defence also had to show that the evidence that was brought was reliable and credible. The reliable and credibility test was a secondary consideration. As such, the appellant asserts the trial chamber imposed an additional hurdle that the defence had to overcome before it could reach the accepted standard required by the jurisprudence to enliven the evidentiary debate. The appellant submits that in light of the trial chamber's explanation of its methodology, this chamber can be satisfied that it applied a heightened standard. The consequences of this error. The appellant has identified the consequences of this error at paragraphs 106 to 113 of the appeal brief and paragraphs 22 to 37 of the reply. However, here is one example of the trial chamber's erroneous approach. From this, the chamber can see how the test in paragraph 5273 was applied in practice. Unscheduled incident, 24th of October 1994, paragraphs 2001 to 2002 of the judgment. The trial chamber sought to rely on adjudicated facts that said that the shot came from a known sniper location of the SRK and that the shots were fired by members of the SRK. Paragraph 2001, adjudicated facts 2752 and 2753. The defence argued that the prosecution's expert evidence was defected. It also produced a defence expert testimony in which it was said that the trees were likely to have blocked the line of sight. The trial chamber held that likely was not enough to contradict the adjudicated fact. Further, it did not have to address the defence's submissions on the deficiencies within the prosecution evidence because it relied on the unrebutted adjudicated fact, quote, instead, close quote, paragraph 2002. Therefore, even when the defence could introduce doubt through an expert and also point to weaknesses in the prosecution's evidence, this was insufficient to bring the accuracy of the adjudicated fact into dispute. Had the debate been enlivened, the prosecution's evidence would not have been sufficient to re-establish the accuracy of the fact as to the clear line of sight, as it would not have been able to overcome the lingering doubt created by the defence expert and the weaknesses in its own evidence. The appellant submits that the standard applied by the trial chamber to rebuttal evidence was erroneous, and as a result, its approach to the evidence tendered by the defence or reliance on inconsistencies or weaknesses in the prosecution's case to enliven the evidentiary debate was flawed. This infected the trial chamber's approach to adjudicated facts throughout the judgment. The examples provided in the appeal brief demonstrate the existence of this systematic error, such that the trial chamber's approach to every single adjudicated fact is called into question. The appellant asserts that this chamber can be satisfied that the trial chamber fell into discernible error and applied a standard that no reasonable trial chamber would, and in fact, ever has. As such, it invites the chamber to reverse the trial chamber's findings to the extent of this error. At this stage, Madam Presiding Judge, Your Honours, I will pass to Mr. Ivatic for submissions on ground 3.
Your Honors, I again incorporate by reference my objection, reservation of rights, and very strong protest as to today's appearance by myself. Again, without the ability to meaningfully prepare with my client and with a reasonable and bona fide question as to his legal capacity to participate, I am limited by my ethical responsibilities to provide you with a very limited, minimal, and shortened summary argument as to the trial chamber's errors as they pertain to a finding of an overarching joint criminal enterprise and my client's criminal culpability for the same. This would be ground 3 of the written appeal. My goal is to highlight the meritorious claim that my client has and to preserve his rights and make a record of the same. In doing so, I do not substitute my participation as being acquiescence nor recognition of today as being the appropriate appellate procedure, nor do I waive anything written in our appeal which I do not have the time to mention. As to the overarching JCE, the judgment is replete with errors, so many that it is rendered unsound, and this chamber needs to take a look at it and correct the same in order to serve both the interests of justice and allow our client, Mr. Ratko Mladić, a fair result in accord with the legal standards. Let's talk about temporal geographic scope. Respectfully, the trial chamber's erroneous approach on the overall assessment of evidence and failure to properly apply acceptable legal standards led to erroneous findings as to an overarching JCE. To start, I would like to draw your attention to the temporal and geographic scope that was found by the trial chamber. That's in paragraph 4232 and in our appeal at paragraph 194. The overarching JCE is defined as lasting from 1991 to 30 November 1995 and is limited to the geographic scope of Bosnia-Herzegovina. It is a fundamental principle of criminal law that there be a temporal coexistence of the actus reus and the mens rea of the prescribed conduct. Adding to the cases we have cited in our appeal brief that support this position, we have the Nahimana appeal judgment at paragraph 313, quote, "The tribunal should have jurisdiction to convict an accused only where all of the elements required to be shown in order to establish his guilt were present." And then later in that same section, "The acts or omissions of the accused under any of the modes of responsibility referred to in Articles 6, 1, and 3 of the statute occurred in 1994, and at the time of such acts or omissions, the accused had the requisite intent mens rea in order to be convicted pursuant to the mode of
I
responsibility.
apologize,
in question.
Mr. Ivitich. I'm advised that presiding judge's signal has dropped again. Could you kindly bear with us for a minute till we reconnect?
Okay. Right. We were disconnected and I think I'm back. Mr. Lukic, you may continue where you left.
Thank you, Your Honor. This is Mr. Ivitich, and I will continue where the transcript stopped. I would also cite to the Simba appeals judgment, paragraph 266, quote, "The inquiry is whether, at the moment of commission, the perpetrators possessed the necessary intent." Indeed, the Natelatic and Martinovic appeal judgment followed this same approach in paragraph 114. And your esteemed colleague, Judge Tuzmukhmedov, who said to call him Judge T, supported this same approach in his dissent in the Shayinovich appeal judgment at paragraph 8. In the words of Judge T, neither conduct prior to the period of the JCE nor any actions on the part of the accused thereafter could have reasonably amounted to a significant contribution to the JCE. We have correctly argued in our appeal that the trial chamber erred in its approach, especially insofar as to infer mens rea from statements beyond the scope of the overarching JCE made in 1991 in Croatia, not in Bosnia-Herzegovina. Appeal, paragraph 304. First, I note that the indictment alleged that Mr. Mladić was not considered part of the overarching JCE until 12 May 1992, when appointed chief of the main staff of the VRS Army. That's in paragraph 5 of the Fourth Amended Indictment. Prior to that month, he neither was on the territory of Bosnia-Herzegovina, nor within the command structure of the VRS Army, since he was in Croatia and the JNA Army at that time. Our appeal, paragraph 203. Indeed, the first error of the chamber is that it violated the aforementioned jurisprudence by trying to attribute his speeches to Bosnia-Herzegovina in 1991, when Mr. Mladić was neither temporally nor geographically linked to those events. That's in our appeal, paragraph 203. Mr. Mladić was not in the chain of command for receiving reports about events, and certainly could not send commands to persons outside of his chain of command, either to commit these crimes or punish perpetrators. The second error in this respect was that the trial judgment performs an analysis of what others, such as politicians, the police, or other armed groups.
Mr. Ivitic?
Yes.
I'm sorry to barge in, but we have lost one of the judges as well, so could you kindly wait till we restart her connection?
Of course.
I think I need to talk. It's muted. Good afternoon, judges. Good afternoon, everybody in the courtroom. IT Judge, one of our judges is disconnected. Judge Kam is back. Anyway, one Judge Ngumu is disconnected, and IT advises that we take the 1 hour break now. To resume, To resume 1:25 Hague time. Is that agreeable? Or we are restored?
The defense is fine with that, Your Honor.
Registry? I mean IT. Are all the judges connected?
Madam Presiding Judge, IT colleagues are looking into the issue, and we will revert as soon as possible once the connection has been re-established.
Can everybody hear me?
Madam Presiding Judge, we can hear you.
We now take our 1 hour break. All rise.
All rise. We will be.